I haven't got my makeup on, but I'm sure this will end up on YouTube as well.
The Kentucky Rules of Judicial Conduct are found in Supreme Court Rule 4.3. Canon 2 states, "A judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities." Canon 2A states, "A judge shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary." Canon 3B5 states in part, "A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice." Please keep these rules in mind as you view the following clips.
As far as the subpoena and me having the to produce documents that I don't have, the Supreme Court in Turub versus U.S. at 98 U.S.
Mr. Steele, with all due respect, you have made your life, my life, Mrs. Steele's life, and Mr. Dutton's life incredibly difficult in this matter, probably to all of our detriments, by arguing irrelevant case law on points that are totally irrelevant to settling this divorce case.
Is this how Judge Myles shows his respect for the law? By prejudging Supreme Court rulings before ever even hearing them? Would you believe or have any confidence in receiving a fair trial after the presiding judge publicly accused you of making his life, quote, incredibly difficult, unquote?
Would I have a right to, make the record? How do you know what I was going to say was frivolous without hearing it?
I apologize, sir. I was simply acting like a dog who's been hit on the head before and barking first and waiting for later. Go right ahead and forgive my interruption.
The official commentary on Canon 2A states, "Public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. A judge must avoid impropriety and the appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. A judge must therefore accept restrictions on the judge's conduct that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly." Put simply, judges are held to a higher standard than the general public and should be aware of that even before seeking office and bear it in mind while carrying out his sworn duties. Judge Myles admits that with regard to John Steele, his first reaction is to prejudge legal defenses and even mere citation of Supreme Court rulings before ever hearing them. Instead of freely and willingly accepting the high standard of his office, Judge Myles describes his own conduct as being that of an abused dog that barks first instead of listening and responding in a civil manner.
Am I going to be allowed to bring in the expert witness for the business and my accountant?
The fact of the matter, Mr. Steele, is that I should probably tell you not only no, but hell no. On the other hand, in an effort to be overly fair to you, I'm going to listen to it. Now, Mr. Dutton is probably going to tear it apart because I suspect he is going to provide ample reason to conclude that the gentleman is not an expert. However, we will go through it.
Are these the actions of a fair and impartial arbitrator, or is Judge Myles evidencing his bias and stating his inclination was to say, quote, hell no, unquote, when John Steele asked if his witnesses would even be heard? Is it fair and right for the judge to express such confidence in opposing counsel's ability to tear apart a party's witnesses before ever hearing them? Is it fair and right for the judge to notify opposing counsel beforehand of the basis on which he would sustain objections and arguments against a party's witnesses? Why does Judge Myles consider it, quote, overly fair, unquote, to merely agree to listen to a party's witnesses? The following morning, when hearings resumed, Judge Myles changed his mind and would not allow John's witnesses. Does this mean that Judge Myles lost all interest in fairness?
Were you given opportunity to account for the money that was taken from the woodshed?
I will object on the basis that the question assumes facts which are not in evidence.
Did Judge Myles just step down from his position as judge to become an advocate acting as counsel on behalf of one of the parties when he objected without the slightest request by any party?
It is my understanding, Mr. Steele, of the law of this Commonwealth that an individual is entitled to represent him or herself if he or she is foolish enough to do so.
Is Judge Myles saying that only a fool could expect a fair trial in his court without being represented by an attorney? In the hearing related to custody, John asked about a dangerous dog that had bitten his children and being allowed to remain in the home for some time even after biting one of his daughters in the face.
Did you allow the dog back in the house after the first time?
Isn't it a rule of law in the world in general that every dog is entitled to one bite?
Again, is Judge Myles acting as an advocate and making an absolutely ludicrous statement in defense of one of the litigants? When pressed further, Judge Myles gave the following warning.
I should inform you, Mr. Steele, that one of the few prejudices I cherish is for dogs.
Is your confidence in the integrity and impartiality of the judiciary increased after learning that the family court judge has an admitted and cherished prejudice for dogs so significant as to allow every dog to bite at least one child? In regards to the fact that John Steele has always done his best to respond to all legal challenges as best he knows how, Judge Myles made the following statement.
Our hearing today is precipitated or created by the fact that I filed a motion on behalf of Ms. Steele.
That'll teach you.
Yes, sir, I know.
Judge Myles had already stated in previous hearings that John's attempts to defend himself using the law and court precedent had made his life, quote, incredibly difficult, unquote, and was a fool for trying. Is Judge Myles implying that John should not defend himself in court? Again, is this an example of a judge who freely and willingly accepts the high standard of his office? Or is this the example of a judge who says the first thing that comes to mind with complete disregard for possibly tainting public confidence in the integrity and impartiality of the judiciary? It should be noted that Kim Steele's counsel, Gilmore Dutton, was on the committee to elect Judge Myles to the office he now holds. Would your confidence in receiving a fair trial be affected by the knowledge that your opponent's counsel worked to get the presiding judge elected?
Your position is duly noted, Mr. Steele. To correct one thing you said during your closing remarks, while this court has on occasion been frustrated with you beyond the realm of control, the court has never disliked you. That is not the issue here.
After hearing Judge Myles curse John and call him a fool who had acted to his detriment and made his life incredibly difficult, does this statement have the ring of truth to you? In the following hearing, Judge Myles apparently didn't realize how soon the recording equipment had been turned on.
Okay, I'll just come down after lunch. Is that okay? Yeah. And I'm leaving before you call this name.
One of the largest mistakes I ever made was letting you out of it. Steele versus Steele.
I think you're the one that actually was elected.
I'm just going to sit back here, Judge, but I'll chime in when I need to, if that's okay.
Rainey,
Yes, Judge, I'm going to be standing in for Mr. Dunn.
he owes you a big one.
I am aware.
Good morning, Mr. Steele.
Good morning.
Would you feel confident in your ability to receive a fair trial after receiving the official record of the hearing and finding such statements being made by the presiding judge? After such comments, he apparently demonstrates great acting skills and his ability to effect a friendly-sounding good morning as soon as John was in earshot.